Yes.
My Lord, I referred you to the model law provisions, which is part 18 of the BVI Insolvency Act. I should refer you as well to part 19, which is page 4827 in volume 5 of the authorities.
4287.
4827.
4827. Thank you.
Should be headed part 19, orders in aid of foreign proceedings. This applies to incoming from the US to the BVI. If you look at 4661, you see relevant foreign country means a country, territory or jurisdiction designated by the Commission as a relevant foreign country for the purposes of that, and the US has been designated as a relevant foreign country for the purposes of this Act. Then 4672, you see a foreign representative may apply to the court for an order under subsection 3 in aid of the foreign proceeding in respect of which he's authorised. I don't ask you to look it up, but if you look at section 2, which is A5/128/4626, court means the BVI High Court for these purposes. Upon an application under subsection 1, the court may, and then it gives them a range of powers that may be exercised, which don't include, I submit, avoidance. If you look at 4681, you can see considerations that are to be taken into account in exercising these powers. And I invite you to look at 4681C, the prevention of preferential or fraudulent dispositions of property subject to the foreign proceedings or the proceeds of such property. And I submit that what that's referring to is using the powers in effect to get money that's been held to be an avoidance in another court. For example, if you look at 4673, authorising the examination by the foreign representative of the debtor or appointing an interim receiver. And then could I invite your lordships to look at 472?
4673H is a very broad power.
It is a very broad power. I submit it would be unusual that to give them avoidance powers by H would not be an appropriate construction of the clause, just because the A is still generous fuel, and if you were intending to cover avoidance powers, you would have said so. 472 is significant because a 472 order was made in this case. If one looks at 1/4/14, it's flag 4/14. If you look at the order that Mr. Justice Bannister made on the 7th of May 2010, it was pursuant to section 4.
Page 14.
So which page?
Page 14, I apologise. I've only referred these to your lordships in order to set out what the BVI cross-border position is, but these are the three bits I've referred you to: the ancillary liquidations under 163, the model law, which is not in force, which is part 18, and part 19, are primarily incoming rather than outgoing, not exclusively, because section 472 was used to appoint the liquidators foreign representatives for the purposes of bringing proceedings to the US. But it's primarily incoming, and therefore it's not of that much assistance to your lordships in determining what the construction of section 249 is.
472, of course, directs the court in deciding whether or not to give such authority to a view of the applicable foreign law.
Yeah.
So if the New York Bankruptcy Court had jurisdiction to exercise the same discretion in accordance with BVI law as a BVI judge and a BVI court. And the judge being approached under section 472 was given evidence of that. Would he be transgressing in any way and authorising the bringing of those applications before the foreign court?
Well, wouldn't it depend on what the judge making the section 472 order was told and considered to be the position under BVI law? Because if the judge took the view that section 249 gave a discretion that could be exercised by any judge in any court in the world, that's exaggerating, but only for effect, then that might be the basis upon which he made the order. If that was the basis upon which he made the order, then it was made on a wrongful basis. But I don't invite your lordships to inquire into that. I invite your lordships to say, is it wrong as far as the defendants are concerned that they should face these proceedings in the US?
One assumes that, I mean, we've looked very closely at section 249, isn't it?
Yeah.
And its reference to the court. I imagine if one was to look wider, lots of provisions of the BVI Insolvency Code as set out in the Act make reference to the court for a multitude of various purposes, with exactly the same definition of court. So it would, and if that supposition is right, I haven't had time to check it, then that would apply to a great many of the possible types of applications.
Assume that there is a lot of references to court, meaning the BVI High Court. The question of construction for this court, or indeed for any court looking at it, is the intention of the legislature that only this particular court can do it. And I mean, examples we've given in our... I went through the examples this morning. It is obvious that some of them are plainly only intended to be exercised by the BVI court, not as an allocation matter, but because it's exclusively a matter for the BVI court to do. The obvious example is the scheme of arrangement. Another example is a winding up order.
Yes. There'll be others, though, where, let's say it's to resolve a challenge on proof, require the production of information.
Challenge on proof.
And they may all refer you to the BVI court.
Yeah, take a challenge on proof. There may be ways in another court whereby the other court can work out whether or not, in fact, X owed the debtor company £20,000 or whatever the figure might be. But it wouldn't be the BVI court that was making that resolution. It would be another court that would be making that resolution, and maybe the liquidator would be authorised to bring proceedings in a foreign court to do that. But and you have to look at this precise provision in relation to it, but admitting to proof or admitting as a provable debt is probably a function that only this particular court can do. The other point on that, my lord, is that and this is the point that Lord Hoffman makes in Cambridge Gas, there will be frequently aspects of insolvency where what you are doing is working out how disputes about what sums are owed are dealt with, which is not part of the collective process. The key bit that is governed by the court is the collective process, and avoidance provisions are quintessentially, in the newfangled way, to use the language of Lord Reid, are part of the collective process. You're not dealing there with the establishment of existing rights. You're working out what, as a matter of the collective, should be within all of the assets. So if and insofar as there are other provisions, then it might be that they could be dealt with by a foreign court, but where you're dealing with what is right at the heart of the collective process, and avoidance provisions are at the heart of the collective process, because as Lord Hoffman has made clear, as Lord Collins made clear in that passage I read you, what they're dealing with is how do you make it fair as to what's available as to the creditors, and that involves setting aside people's otherwise legal rights to hold on to money.
Does it follow from that, then, that your case on construction isn't really at its heart based upon the proposition that the Act uses the word court, and then a definition section says the High Court in the BVI. Because there may well be numerous other provisions which we haven't yet looked at, where the Act also uses court, where, for example, by cross-referencing to 4673 and the list there, it really isn't meant to confer exclusive jurisdiction. So that the question of construction turns not so much on the language as the nature of the power which is being created.
Well, I referred you to, Mr. Justice, the member of the High Court of Alberta, and said it's three things, isn't it? It's construction, policy and comity. Those are the three things. I need the construction on the face of it supports me. Put it
Could go either way if there are lots of others where it's the same language.
But I appreciate completely that you could easily find another section in another act where it was obviously an allocation provision. So you've got to look at the context in which the words appear. I am submitting there is this construction which leads you initially to that conclusion. The context, I submit, strongly supports that's what's in mind. I submit as well comity supports that, because you don't allow other countries to apply your avoidance provisions unless there is an international agreement to that effect. So if and insofar as you're putting to me, well, it can't always be the case that a reference to a court having a power to do something equals only that court. I accept it will be easy to find other provisions in other statutes. But
I'm talking about this statute.
Well, I can't go through. Do you want me to?
No.
I mean,
just asking you.
Is the question? Well, look, aren't there other provisions that you, on behalf of the appellants, concede are allocation provisions, even though they're in the same sort of language as this? Is that the question?
Yes. In this statute.
I can't point you to any, but that is not because I can't guarantee that there aren't. It's because I wouldn't be well acquainted enough with the statute to say what the position is. I say that you've got to look at this statute and this provision and put it into its context.
I mean, just so you know what's concerning me, it strikes me as prima facie unlikely that a statute would ever confer jurisdiction in express terms on a foreign court.
Yeah.
Whether a foreign, and therefore it's no surprise to see a statute when it refers to the court is always talking about a court within the jurisdiction of the legislature.
No, I completely accept that.
In question.
The question for the court is the nature of this right one where it's not inextricably linked to the BVI High Court? The easier example is the one referred to by Lord Hoffman in the case in Bermuda, the scheme of arrangement. It's obvious that the right to have a scheme of arrangement depends completely on court intervention. I say that Section 249 is in exactly the same category. Courts have jurisdictions, and if you look at, which you obviously have, at Lord Collins's definition of what avoidance provisions are about, you would expect provisions about avoidance to be ones that would very much depend upon the exercise of a discretion by the court of the jurisdiction, because, as Lord Collins said, they reflect the public policy of that particular place. Compare and contrast what the position was before 1985 or 1986, where what you had was in effect black letter law provisions, which in effect said if you, and this is concertinaing it, if you deliberately and fraudulently pay one creditor with a view to defrauding another, then the creditor can bring proceedings, and if he or she can establish that the black letter requirements are set out, there's no discretion, it's not part of the collective approach to the question of insolvency. And so, to go back to your Lordship's question, well, aren't you going to be able to find lots where it says the High Court, but it doesn't mean it? You might be able to, yes, But the question is, in this case, is the intention of the drafter to create a scheme where there is one court that in effect determines what the size of the pot is, including the extent to which you can increase the size of the pot by reference to transactions that would otherwise be lawful apart from the avoidance provisions. And I respectfully submit that the norm there would be that you wouldn't allow another court to do it. That's reflected in the wording of the statute, and that's consistent with both comity and public policy. But if and insofar as you're saying to me, doesn't it depend upon the context, I completely accept that. But that's what I say the context is.
Just on that, I noted that Section 252 of the Insolvency Act provided that the remedies under the specific sections were not exclusive.
Well, isn't that dealing with the provision whereby, suppose that you're not relying on the avoidance provision, but you are, under these provisions, but you are, for example, reliant on Section 80 of the tell you what it's called.
Yes, I can see that, but it's entirely general and a remedy anywhere.
No, I think, in my respectful submission, what it's saying is the fact that you can avoid a transaction under this provision doesn't mean that there may not be other grounds on which the provision might be avoided. For example, straightforward fraud. For example, under what is Section 81 of the Conveyancing and Law of Property Act of the Law of the Virgin Islands, which is in effect the old Section 172 of the Law of Property Act 1925.
Section 43. Yep.
Which is now Section 4, well, which became Section 423, but in a slightly different form. Yeah, that's correct. So in my respectful submission, you can't draw, you would be making a mistake to draw out of Section 252. This doesn't prevent other foreign courts applying Section 249. Well, can I go on to my fourth chapter, which is errors by the Court of Appeal? My Lord, you find the Court of Appeal judgment at bundle 1, flag 18, which is page 166 in the electronic bundle. The relevant part of the decision on this bit is 214 through to 216, effectively paragraph 79 to paragraph 81. It's quite short. My Lord, in my respectful submission, paragraph 80 is where the key error is. Error number 1 is that the ECCA, if I may call them that, concluded that the reference to the court in Section 249 was a procedural provision. This was wrong for the reasons I've gone through earlier. This is the error which is fundamental to their analysis. The errors which I mentioned to follow are largely steps on the road to this fundamental error. Error number 2 is in para 79. The ECCA rely on the fact that it's commonplace for a court to apply foreign laws, and the focus of international business for companies such as the funds is for the conduct of international business, so all the more so should they expect, in effect, foreign insolvency law to be applied. Of course, the foreign business person should expect, for example, BVI law, the proper law of the contract, to be applied in foreign courts. But that tells one nothing about the construction of Section 249 and the extent to which foreign law will be applied in the context of cross-border insolvency. And simply to say you would expect, as indeed you would, that BVI companies would be engaging in international commerce doesn't assist you in concluding what Section 249 means. Error number 3 is to be found in para 79. The ECCA considered their construction was supported by the proposition that, consistent with the universality principle, all creditors should be treated equally under the same law, that's what's said in paragraph 79, that is a statement of untrammelled universality and is also failing to give effect to modified universality, which involves striking a balance between there being one law that applies to the whole of the insolvency on the one hand, and on the other, truly respecting the territoriality of the place where assets or debts may be situated. In any event, that question primarily arises in the context of incoming assistance rather than outgoing assistance. And then error number 4, again para 79, it would be absurd indeed were the BVI court able to grant relief in aid of foreign proceedings, but a foreign court could not grant relief in aid of BVI proceedings. Again, that's paragraph 79. I submit two things. One, that's not the test. The question is who can apply section 249. And one has got to be careful to recognise that reciprocity is not the test in this area. But separately from that point, I submit that the position is that although certainly the BVI courts can grant assistance to a foreign court in aid of a principal insolvency, it doesn't include applying the avoidance provisions. But even if it did, that wouldn't lead to a different construction of section 249. And then error number 5, this is paragraph 80. It says that the BVI court has no personal jurisdiction over the bulk of the defendants in the US proceedings. Paragraph 80. Wrong. It does have, it has personal jurisdiction over all of them. See Rule 7.310 of the Eastern Caribbean Civil Procedure Rules, which I referred your Lordships and your Ladyship to earlier, which is to be found at A5 127 4606 in the bundle at 4610. And I don't ask your Lordships to look it up because we've already looked it up already. My Lord, can I take out of order, can I deal with the US position at the end and just deal with what I say is the position in relation to BVI law? The Court of Appeal has plainly made those 5 errors that I've just gone through. The key error is believing it's procedural, the reference to the court, therefore any court can apply it. It would be a very significant finding that they could apply it, because it would be a finding that would have an impact across a whole range of insolvency avoidance statutes, not just in the BVI, but in the common law world. My Lord, what's the right, for all the reasons I've given, I say it's only the BVI court that can do it as a matter of construction. But Lord, what's the right remedy in this case? I submit that the right remedy is, I put it in the alternative. First of all, your Lordships can make a declaration. The declaration would be to the effect that the BVI court is the only court authorised to make a finding or an order under section 249 for all the reasons that I've indicated. The circumstances in which the English or the BVI courts make a declaration is when it's useful to do so. I don't ask your lordships to turn it up, but there's a decision called Rolls-Royce and Unite, in which my Lady Arden was one of the members of the court, which is, and don't look it up, but it's A31114169. There's an issue, it's a completely different case. It's about a collective agreement and the rights of employees. But the court effectively enunciates the principle, will grant a declaration when it's of assistance to do so. I respectfully submit it would serve a useful purpose here because of the scrupulousness with which the US courts have followed all the steers and rulings that have been given by the BVI courts. And I identified the three examples of that. The stay after Miss Justice Bannister dismissing the claims to recover the redemptions. His Honour Judge Bernstein in relation to the Privy Council's view that New York law had nothing to do with it. And then in this very case, this very application, His Honour Judge Bernstein's view at page 41 of his December ruling that it's because of what the ECCA had said that he was minded, or not minded, he just refused to make the point. So we submit that in the first instance, it's open to this court to grant a declaration, and the US court should not go ahead on the basis that the US court had the power to do it. My junior is referring me to para 56 of the terms of the declaration we seek is to be found at 3340. I don't ask your lordships to look it up now, paragraph 56. But I think your lordships have got the idea of what I'm asking for in relation to that. Then, if that declaration is made, then as a matter of practice, what would happen is that there would be a further motion to dismiss in order to strike out the claim. The old motions to dismiss have not yet been concluded because there is still an issue about whether or not the safe harbour provisions of American law apply. I don't think I need to go into those in detail, but in any event, there is no requirement that the judgment from the Privy Council, if there was such a judgment reversing the ECCA, would need to be introduced as an appeal. It could be done simply by telling the court in the US what the position is, and I think your lordships would be entitled, and your ladyship would be entitled to conclude on the basis of the way that they've operated, they would follow that. But, my lords, I put the case not just on the basis of declaration, but as an anti-suit injunction as well. My lords, the principles of an anti-suit injunction are not in dispute. Look at paragraph 46 of our written case as to what they are. They have a particular use in insolvency cases. And could I ask your lordships just to look at in A3 of the authorities bundle, flag 115, Stichting Shell Pension Fund, and Chris, who is the very same Mr. Chris as in this case. So he's been one of the greatest contributors to the development of law in cross-border insolvency ever.
Oh, I can think of some others. But,
No, but I mean,
what's the page number?
4341. And this is about can you stop an attachment proceeding? This is the liquidator stopping attachment proceedings going on in a foreign court, basically. And that's the context in which these issues normally arise. But could I invite you to look at Lords Toulson and Lord Sumption deliver a joint judgment of the Privy Council. And at para 14, they consider the question of what are the circumstances in anti-suit injunctions in insolvency cases that you grant injunctions. And could I invite your lordships and your ladyship to look at paragraph 24 of the judgment, which is 4352. And letter E, I mean, don't read the whole paragraph, but just above paragraph E, where a company, down to the end of the paragraph, My Lord,
But you could have principal and ancillary liquidations, which distribute to creditors, so that the jurisdiction of the insolvent's domicile would not, in that situation, be the only.
yeah, what I submit Lord Sumption and Lord Toulson are saying is that you can grant an injunction to ensure there is, in effect, a liquidation in accordance with the rules. And it's not just for the creditors and the members, but for the wider public interest in relation to that. If the rules say, and I say that they do, that it's only the BVI court that can grant avoidance relief, yes, there are other things that can happen in the US, like an ancillary liquidation, then an injunction can be granted to ensure the rules are complied with. Otherwise, you end up in a disorderly liquidation where steps are taken by the liquidator, just as steps can be taken by creditors, which are not in accordance with the overall position.
But thinking it through, if the liquidator succeeds in obtaining compensation for the company on avoidance of transactions in the United States, where will he put those proceeds?
Bring them back to the BVI.
Exactly, so they get distributed within the BVI.
That's correct, but in accordance with, under the normal rules, with the US avoidance provisions. If the BVI avoidance provisions are to be applied, then the debtors and the creditors should expect, and this is what the law has provided, that only the BVI court should do that. And I put that as a point of principle, which of itself justifies the grant of an anti-suit injunction, because you shouldn't be able to, if you're the liquidator, say, despite the fact I've only been given power to ask the BVI court to avoid the transactions, nevertheless, I'm going to go to another jurisdiction as well.
But on your approach, looking for the anti-suit injunction, it would be unusual for a court supervising a liquidation to have to injunct an officer of court to prevent him acting illegally, if you're right.
Yeah.
In this case, the liquidator went to the BVI court and got permission to raise proceedings in America precisely on Section 249.
Yeah.
So why do you need an injunction? If you got your declaration, wouldn't that be enough? Combined with perhaps with a revocation of the previous license to proceed.
I'd be happy with that.
I mean, it seems a fairly hefty mallet to hit the liquidator with over the head to seek an injunction.
Yeah, no. I mean, if this court indicated that that's what Section 249 meant, and therefore it will almost certainly follow that the revocation, that of course
you'd be home and dry.
I wouldn't press it. I wouldn't need it. That's fine. So I'm being a bit too heavy, maybe, in relation to that. I mean, it's interesting what my Lord Hodges said, because I was going to say that one of the problems in the case, and it's absolutely no fault of the US court, the ping pong that has gone on here has led the thing to last for a very long period of time. Whereas if there had been a definitive ruling earlier on about what the position was in relation to the meaning of Section 249, then it would have been a lot shorter. My Lord, my last, well, it was my second to last, but now it's my last, the US position. It's not for this court to make any findings about US law. The only case I would refer your lordship to is the Hellas 2, which is A4-118-4475. And I don't invite you to read it at any great length. What happened in that case was there was a Greek telecom company. There was a sale of some assets, and the liquidator, even though England was the natural forum for these proceedings, brought proceedings to try to avoid the payment out of the proceeds of the sale of the Greek telecom company to various investors, and he tried to bring the proceedings in the US. The defendants in those proceedings, who are two groups, one of them is called the Apax defendants, and that is significant subsequently. The Apax defendants said you can't give the relief. It was a claim under section 423, which is the old 172, and a claim under section 213 of the Insolvency Act, which is fraudulent trading. And the argument in America was you can't give this relief because it can only be given by the English court, and indeed Mr. Moss was the expert witness in relation to it, and Mr. Isaacs from Mr. Moss's chambers was the expert witness on the other side. And what His Honour Judge Glenn concluded was actually the reference to the discretion in section 423 didn't mean that it had to be done in the English court. It was only a procedural provision. But he went further than that and said even if it wasn't a procedural provision, nevertheless, we in the US courts can override these provisions and are not stuck with what he describes as exclusive jurisdiction provisions. And His Honour Judge Glenn said, we haven't got a, quote, determinative decision in relation to that, but that was the view that he expressed. The limitation period got close to expiring in England in relation to the Apax proceedings, and the liquidator issued proceedings after the decision in the Hellas 2 to protect himself against the limitation period expiring in England. And he then, liquidator then went to the Chancery Division before Sir Geoffrey Voss and applied for a stay, saying, can we stop these proceedings in England so that they could be heard in the States? And Mr. Justice Voss, Sir Geoffrey Voss, as he then was, I think is still, said, I'm not going to grant a stay because the right place for these proceedings is in England. So I'm not going to grant a stay, but I'm not going to say anything about whether or not these proceedings should go on in the United States of America. In the light of what Sir Geoffrey Voss had said, the defendants then went to America and said, it's obvious these proceedings should be stayed in America in the light of what Sir Geoffrey Voss has said, and indeed His Honour Judge Glenn then stayed the proceedings in America. The matter then came on a trial before Mr. Justice Hilliard, and Mr. Justice Hilliard, after 4 days in front of Mr. Justice Hilliard, the liquidators abandoned their claim, and an order for indemnity costs was then made against the liquidators. I tell you this exotic and exciting story, not because it's so thrilling, though it is, I thought, quite thrilling, but because it indicates the danger of the principal court, in this case the BVI, not being willing to say, actually it's obvious this case should be tried in the BVI and not in the US, or in that case in the US and England. What you've got here, and this is, as it were, putting it to one side away from the principle, is the fact that the only reason it's in the US is not to chase assets that might have been hidden there, not to get a situation where you can more readily enforce a foreign judgment if you get it, because there's no difference between the BVI and the US in relation to that, just because the liquidator would prefer, for the matter, to be in the US rather than in the BVI. There is no proper basis, quite separately from my section 249 point, as to why the matter should go ahead in the US, and the right course for the BVI court as the principal court of the insolvency would be to say this case should never have gone to the US in the first place. Now, all of these points have only come up since 2014, when the BVI court in effect said you can't have the redemptions back. That was a conclusion reached by the Judicial Committee of the Privy Council on the 14th of April 2014. We have since then been trying to bring to an end the Fairfield Redeemers litigation because we've effectively won it. If there is a point about whether or not BVI insolvency law applies to allow you to avoid it, and there probably isn't, because if it's an ordinary course of business payment, there is no right to avoidance, then the obvious place for that legal point, and it's only a legal point to be resolved, is in the BVI. And there are no obvious advantages to that being decided in the US. And if I'm right in my construction of Section 249, which I will submit that I am, it's completely wrong that it should be the US court that is exercising a discretion to determine whether, having concluded at common law that they can't have the redemptions back, could they get them back by the back door under Section 249? And had they asked Mr. Justice Bannister to give a ruling on that, rather than deliberately not including it in the original litigation, these cases would have come to an end a long, long time ago. And it looks incredibly like not a situation where a liquidator is looking for assistance because somebody is squirreling money away, which is exactly the circumstances where there should be cross-border insolvency, but it looks like a situation where a liquidator is looking for a court where it may be more intimidating for the defendants to find themselves than the BVI. So,
but we're not answering. We're not being asked to answer questions about forum convenience today.
no, you're well.
I mean, the issues before us in the statement of facts and issues are clearly focused on the interpretation of Section 249.
I agree with that. But I submit that if you come to the conclusion that I'm right in relation to my construction of 249, and you were to conclude that there was a discretion in relation to whether to grant an anti-suit injunction, then the peroration I've just gone through would be of a relevance to your lordships in determining how you would exercise that discretion. So that is the justification for it. But I'm not taking your lordship on in relation to that particular point. My lord, those are my submissions. Unless there's any other point I can help your lordship on, or your ladyship on.
Thank you very much indeed, Lord Faulkner. Mr. Moss.
The court. We rely on all the matters set out in our case. We submit that this appeal should be dismissed for a number of reasons. First of all, the primary relief sought in the Privy Council here is an anti-suit injunction. Apart from special cases which don't apply here, such as the Chris and Shell case that you were showing earlier on, which was an exceptional case to do with the integrity of the estate, not allowing parts of it to be seized by somebody who had submitted to the liquidation in that case, leaving aside special cases of that sort. An anti-suit injunction, being a very serious interference with the jurisdiction of the foreign court, requires, as a basic matter, that the claim in the United States, in this case, should be vexatious and oppressive. This has never been demonstrated in this case at any level, and has not been demonstrated here. In fact, my learned friend, unless I missed it, did not even use either of the words oppressive and vexatious throughout his entire peroration. Both the ECCA and the US judge have actually held that the liquidators were correct in their submissions in this case, because the relevance of that is that the only basis on which oppression and vexation had been run below was that we were wrong. Well, of course, that isn't a good enough ground anyway, because the question of whether or not one is wrong is an issue, a substantive issue that has to be decided. The question is it to be decided in the BVI or is it to be decided in the US? But nevertheless, both Ms. Justice Leon and the ECCA and the US judge have held that our approach is correct on the underlying matter. And very importantly, the underlying question is not the construction of Section 249 under BVI law. The underlying matter, underlying question, is the question of whether the US court has the power to apply under US law, Section 249, to give relief. Now, not only has it not been shown that that's unarguable, it's actually been shown that we're right so far in terms of both the ECCA and the US judge. Secondly, Ms. Justice Leon exercised a discretion to refuse the anti-suit injunction. That discretion, the exercise of discretion, was upheld by the Court of Appeal. The grounds of appeal, which I'm sure your lordships and my lady have read, give no basis, pursuant to the Hadmore criteria, for setting aside the exercise of the discretion. Third point, Mr. Justice Leon held that the appellants had no proper interest to apply for an anti-suit injunction. This point was not dealt with by the ECCA. The grounds of appeal to the Privy Council by the appellants make no mention of this at all, even though there is an outstanding decision on this point at first instance. Nor has it been mentioned by my learned friend Lord Faulkner in his submissions. The point here is it's not enough to say we have standing because we're being sued abroad. That may give you standing in many types of cases, but the facts here are rather special. The primary relief being sought in the BVI was what was called the Section 273 relief. That's the attempt to interfere with the exercise of judgment by the liquidators in bringing the actions in the United States. That decision was backed by the Court of Appeal in giving sanction ex parte. The appellants could have applied to have that sanction revoked. They never applied. So throughout this, we've been operating with a sanction of the East Caribbean Court of Appeal. Now, as I said, the Section 273 application was the primary application, and the anti-suit injunction application was simply put in as an alternative because they must have realized that they had very serious standing problems on the authorities, on the English case law, very serious standing difficulties in relation to Section 273. Because they're not creditors, they're not the debtor, they're not any of the normal people who apply to interfere with the liquidator's discretion. So the anti-suit injunction application was only there to get round the standing issue. And it's in that special situation that we say that Mr. Justice Leon was entirely justified in saying that they had no proper interest in the relief because it was only a dodge or an attempted dodge to get round the lack of jurisdiction under Section 273. If this dodge worked, it could be worked in every case. The whole idea of standing under Section 273 would disappear. Now, next point is that whenever an anti-suit injunction is applied for, it's settled, as I mentioned earlier, that unless there's a special reason, the English courts leave it to the foreign court to decide whether or not a case should continue before the foreign court. And could I ask your lordships and my lady to go to our case? It's the easiest and quickest way of doing this. at paragraph 47, page 3363. Now, paragraph 46, we refer to the general criteria in the oft-quoted case of Deutsche Bank and Highland Crusader for anti-suit injunctions. But that's quite general, and we're in a specialized field here, cross-border insolvency. So paragraph 47, we go on to the specific ruling upheld by the Court of Appeal in that case, and since quoted, for example, I think in the Chris and Shell case, of Mr. Justice Hoffman as he then was, in the Maxwell case, Barclays and Oman. And there's the quote there, "Today the normal assumption is that an English court has no superiority over a foreign court in deciding what justice between the parties requires, and in particular, that both comity and common sense suggest that the foreign judge is usually the best person to decide whether in his own court he should accept or decline jurisdiction, stay proceedings, or allow them to continue." And there's a quotation from Lord Scarman in Laker. Moving on to the second paragraph, in other words, there must be a good reason why the decision to stop the foreign proceedings should be made here rather than there. Although the injustice which can justify an anti-suit injunction must inevitably be judged according to English notions of justice, it will usually be assumed that a similar quality of justice is available in the foreign court. So the fact that proceedings would, if brought in England, be struck out as vexatious or oppressive in the domestic sense will not ordinarily in itself justify the grant of an injunction to restrain their prosecution in the foreign court. The defendant will be left to avail himself of foreign procedure for dealing with vexation or oppression. And as your lordships and my lady will know, that is exactly what UBS and Co. did. They took full part in the application to dismiss on a whole number of grounds, including the present point. Having done so, they failed miserably on section 249. But they've had justice, they've had very good justice from the US bankruptcy judge. So in our submission, the normal rule applies. It's up to the foreign judge to make a decision whether the matter is to continue in his court or not. The foreign judge has made that decision. And that is the end of the matter in our respectful submission. The next point is that at no stage did the appellants seek an interim anti-suit injunction in the BVI. To the contrary, they took full part in arguing this same point, amongst many others in the US, with the result that the point has now been decided. The only point of continuing the present appeal is to try and use it as a de facto appeal from the US bankruptcy judge. As your lordships and my lady will know, the Americans do have their own system of appeals, and it is to that system that any grievance needs to be taken. Our respectful submission to try and use the Privy Council as a de facto court of appeal from the US bankruptcy judge is an abuse. The next point is that the real underlying issue here is whether the US courts under US law have the power to use BVI statutory avoidance provisions. And this is entirely a question of US law and not BVI law. The appellants actually agree with this, not that Lord Faulkner has reminded you of that. But if we go to tab 79 in the documents bundle, see this precise concession made in the grounds of appeal at page 3279. At the top, in lines 2, 3, and 4. Question of whether a foreign court is able to grant relief in aid of BVI insolvency proceedings is a matter for the law of the relevant foreign state. There we have it. In a nutshell, this is not a question of construing a BVI statute under BVI law. This is a question of the powers of the US court under Chapter 15 of the US Bankruptcy Code. That is quite separately and independently a complete answer to why this question should be decided, and has been decided, in New York. The underlying US law question depends on two things. First of all, does the US court interpret the BVI statute as prohibiting its use by foreign courts? And if so, secondly, whether any such prohibition is characterized by US law as procedural or substantive. This point again has been conceded by the appellants. If we look at tab 84 in the documents bundle, page 3339, right at the end of tab 84, those who have tabs, in footnote 44, they're kind enough to quote me from below, apparently with approval. See the submission of Gabriel Moscow, see, quote, so the two questions for the US courts, just to be clear, are, first of all, is there something in the BVI statute which prohibits foreign court from using section 249? Secondly, if there is such a prohibition, is it procedural or substantive? So both sides actually accept that the issue is one of US law interpretation, both on the question of is there a prohibition and on the question of whether any prohibition is substantive or procedural. Now, I imagine the board will know that there is no unanimity throughout the world as to what is procedural and what is substantive. Even in the common law world itself, as Dicey points out, there are fundamental and significant differences. The question here being one of US law, that question has been decided by the US judge, and it is his decision that matters. Again, the board, however eminent, is not a de facto appellate court from the US judge. It is not a question for the board to decide either of these two US law interpretational issues.
And you would say that that's so even if the US court has jurisdiction to interpret the BVI statute?
It certainly does. As any court which is applying foreign law necessarily has jurisdiction to interpret that foreign law, if it's a statutory provision.
We've only so far been shown the provision in the New York judgment which simply said, well, look, the answer is in the Eastern Caribbean Court of Appeal. Have they gone further than that?
No, they haven't, but that's actually my next point.
Because if that was wrong, I mean, it rather looks as if the New York court is deferring to courts that habitually apply the law of the jurisdiction.
No, with the greatest respect, that's not our reading of the judgment. Can I take you to judgment?
Yes, please.
That's exactly where I was going to go next. And that we find at the other side to put it in the authorities bundles at 4116. So my friend Lord Faulkner read you the two sentences, but he didn't read you the sentence before the two sentences, so you could get it into context.
Sorry, 4116.
It's
Page 4361.
It's volume 4 of the authorities at page 116. I'm sorry, tab 116.
Got it.
And
Wait, the pages?
the page is 4401. What he didn't read you was the bit right at the top. The defendants raised several objections to the BVI avoidance claims, but only the objection under the Bankruptcy Code requires extended discussion. And again, what learned friend didn't explain was there were actually US authorities which pointed the court in the direction it arrived at. But as the court will know, sometimes writing judgments, shortcuts or abbreviating approaches can be taken. So Judge Bernstein could have said, all right, I'll give you a full treatment. I'll set out all the US case law, including Hellas 2, and then we can look at the ECCA as well. But he took a shortcut. How he runs his court, how he writes judgments, and so on, in our respectful submission is a matter for him. And if the appellants don't like it, there are appellate courts in the US that can deal with that. It's not for the Privy Council to mark his homework, as it were. The fact that he dealt with it so briefly, and the introduction that Malone Fred didn't read, shows you how little he thought of this point. This is a lengthy judgment. It deals with a number of things at length. They ran very, very many points. But on this one, it was pretty straightforward, and he took this shortcut by cross-referring to the ECCA judgment. Now, in our respectful submission, the cross-reference to the ECCA judgment doesn't change the nature of the question. Question is a question of interpretation according to US law. That can be informed by looking at interpretation under BVI law, English law, perhaps other laws. But it's not decided by the interpretation under BVI law. That's only a factor. And referring to the ECCA decision in this way, in our respectful submission, doesn't change the underlying question. The underlying question remains a question of US law. Citing foreign authority from other common law jurisdictions does not change the law that one is considering.
Well, where did the judge give an indication that he was thinking of something else?
He doesn't. One would actually have to go back to the very detailed submissions of law that were made to him. And I can also show the court, in due course, the authorities that were already available, which pointed in the same direction in the United States. My slight reluctance is that we are then embarking on an exploration of US law, which is not really the function of the Privy Council in our respectful submission. But if I have to do that, I will, and I had to do it below.
It might be helpful to say a little bit about it, because the argument against you, I think, was rather suggesting that he had rubber-stamped the judgment of the ECCA, whereas,
yes.
As you're saying, it isn't simply a question of what BVI law is.
Absolutely. Yeah. Absolutely. Yeah, we can certainly go to that next. I think I was going to deal with this later, but perhaps the way into this is as follows. If I can just put this away for a minute. The BVI courts, when it considered what we say is the real question, which is the power of the US courts to apply BVI avoidance law, had to rely on evidence. Now, the only expert evidence that was put in by the liquidators. That evidence said that the US courts did have the power to apply US avoidance law.
But why would it have to rely on evidence about its own powers under its own law? People often criticise the English courts for relying on evidence of foreign law, but to rely on evidence of your own law seems extraordinary.
I'm sorry.
I may have misunderstood what you said. You said that the US judge, in deciding what US law gave him the power to do, had to rely on evidence.
Yes.
Which seems a rather strange proposition.
No. I'm sorry. It's entirely my fault. This is just a way of getting into the cases by looking at the evidence.
Oh, you mean it had to be presented in a series of witness statements or something?
Exactly.
Are we talking about expert evidence before the US court or before the BVI
court?
That's what I thought, before the BVI court. And this is expert evidence about US law.
Yes.
In front
I'm so
of the
sorry.
BVI courts.
I misheard.
No, I'm sure it's my fault for not being clear. We go to volume 1, which has the... Yes, the affidavits of witness statements. So at first instance, before Mr. Justice Leon, so the only expert evidence that was put in on our side. This expert evidence was neither contradicted nor cross-examined. When I say not contradicted, as one of our footnotes in the case points out, it was contradicted in a very odd sense by that counsel then appearing alongside Lord Faulkner, kind of setting himself up as a sort of amateur expert on US law, and attempting to...
Amateur would probably run. There was a paid element to that, I think.
Paid amateur. English leading counsel telling Mr. Justice Leon what the US law was. And I think the exercise was attempted to be repeated to some extent in the East Caribbean Court of Appeal, but has not been tried again at this level. If we look at Mr. Moulton's witness statement in tab 30, volume 3, record bundle 3.
Page.
393.
Oh, I'm sorry, 406.
Yep.
Now, the relevant evidence for present purposes, your lordships and my lady will appreciate we had to cover a much wider field at that point. But if we can go to 406, starting at paragraph 29. For present purposes, can I just ask the court please to read 29, 30 and 31. Now I can pretend to be a US lawyer, and we go to the Condor first of all. That's at volume 4 of the authorities at tab 120 at 4543. This is a decision of the United States Court of Appeals for the Fifth Circuit. So it's at the appellate level in a particular part of the United States. This is about a Nevis insolvency. I ask the court please to read the part of the head note that says background and holding. Then we can go to key item 6. Key item 6, this is a way of analyzing the various subjects in the head note. The bankruptcy court has authority to offer avoidance relief under foreign law, the Chapter 15 bankruptcy proceeding. In due course, if I get the time, I will try and explain the function of Chapter 15, how it relates to the model law, and so on in due course. But just dealing with this as an authority under US law, if we go to the right-hand side column, first paragraph, this appeal concerns the jurisdiction of a bankruptcy court to offer avoidance relief under foreign law in the Chapter 15 bankruptcy proceeding. Chapter 15 is, of course, the US version of the answer trial model law. We hold that the bankruptcy court has that authority and reserve the judgment of the district court as missing for want of jurisdiction. And then 2 paragraphs down, Fogarty and Tacon, as foreign representatives, filed a Chapter 15 bankruptcy proceeding in Mississippi, contending Condor Insurance fraudulently transferred over $313 million in assets to Condor Guarantee, Inc., to put them out of the reach of creditors during the Nevis proceeding. Chapter 15 permits foreign representatives, foreign solvency proceeding to seek assistance from US courts. Ancillary proceeding, once foreign proceeding is recognized by the bankruptcy court as a foreign main or non-main proceeding under this chapter. Of course, in the present case, there has been recognition as a main proceeding of the Fairfield proceedings. The bankruptcy court recognized the Nevis winding up proceeding as a foreign main proceeding. Foreign representative filed an adversary proceeding alleging Nevis law claims against Condor Guarantee to recover the assets. Condor Guarantee moved to dismiss the proceedings as avoidance actions only available through Chapter 7 or 11. Those are the domestic types of liquidation or restructuring. As Condor Insurance is classified as a foreign insurance company, it is prohibited from filing a Chapter 7 or 11 case. At the bottom of the left-hand column, 4 lines up, our question is whether the exceptions listed in section 1521A7 to the relief available in the ancillary proceeding exclude not only avoidance actions under US law, but also exclude reliance upon domestic law of the foreign main proceeding. If I could just try and explain that. The adoption of the model law by the United States was done in quite a peculiar way. The original model law seemed to envisage that under the model law, when adopted, domestic remedies like avoidance would be used, not the foreign law remedies. But in the United States, instead, they specifically banned the use of domestic remedies unless you open a US plenary proceeding. So the question was, did that also impliedly exclude the use of the foreign law avoidance remedies? Then the right-hand side column, second paragraph, our interpretive task, in part guided by the circumstance that Chapter 15 implements the UNSTRAL model law, directs courts to consider international origin, and so on. If I could ask the court to carry on, read down to the bottom of the page, and then turn over to the right-hand side column. The right-hand side, first complete paragraph. Chapter 15 provides for the recognition of a foreign proceeding, an ancillary proceeding to assist the foreign proceedings. In the next paragraph, foreign representatives seek relief. 1521A provides the bankruptcy court may grant, quote, any appropriate relief. Bottom of that paragraph, granting any additional relief that may be available to a trustee, except for a relief available. And those are the domestic provisions. Whilst it is plain that relief under
those are the domestic avoidance
Yes.
provisions.
Yes.
Sorry.
Yes.
Yes, we see that in the next paragraph.
Yeah.
Whilst it is plain that relief under the listed sections is excluded, the statute is silent regarding proceedings that apply foreign law, including any rights to avoidance such law may offer. Now, if we go over to, or perhaps starting right-hand side on page 4547, could I ask the court to read from the last line, to be sure section 1523A grants, and then the next page, that's 4548. At the top of the next page, 4549, 3 lines down, additionally as a catch-all, under section 1507, the court has authority to provide as additional assistance to a foreign representative subject to the restrictions elsewhere in the chapter. The structure of chapter 15 provides authority to the district court to assist foreign representatives once a foreign proceeding has been recognized by the district court. Neither text nor structure suggests additional exceptions to available relief, though the language does not explicitly address the use of foreign avoidance law. It suggests a broad reading of the powers granted to the district court in order to advance the goals of comity to foreign jurisdictions. And that's the particularly significant passage.
Yes.
And if we go over to 4550, could I ask the court to read the right-hand side column, which has an interesting analysis of the approach of the UNSTRAL working group. Then again, the next page, 4551, please. When the court's ready, I want to go to the top of 4552 in the left-hand side column. Our interpretation is also supported by court's interpretation of Section 304, predecessor of Chapter 15. Congress intended that case law under Section 304 apply, unless contradicted by Chapter 15. And I can just, we can actually read it in the right-hand side column. There's a quotation. Early authorities suggested bankruptcy courts had discretion to authorize utilization of the avoiding powers of the Code in a Section 304 ancillary proceeding. Indeed, a foreign representative could use avoidance powers under both US and foreign law. However, a bankruptcy court in Re Metzeler found that only those avoidance actions relying on foreign law were permitted under Section 304. So the statutory antecedent of Chapter 15, as interpreted by the US case law, said that only the foreign insolvency laws avoidance remedies could be used, and not the American ones. And that is the approach that is followed in Chapter 15, based partly on the presumption that Congress has not overturned the old case law unless it's expressly said so.
Could I raise one matter with you, Mr. Moss? There may be an argument against you that that this is simply concerned with the foreign law insofar as it provides for avoidance of the preferential transaction as distinct from consequential orders following on from the avoidance. In other words, if one looks at the references to foreign law and rights of avoidance, it'd be giving it a rather narrow construction as referring purely to the avoidance and nothing else.
Well, in our respectful submission, I mean, this is one of what's been called the old style of provision.
Yeah. Nevis was operating a 1948 Act type provision, was it?
Yes. So, but there's no indication that the foreign law wouldn't also apply to remedies.
Yeah. Well, I see on page 4547, top of the left-hand column, the second full sentence, referring to the exceptions, says that while it's plain that relief under the listed sections is excluded, the statute is silent regarding proceedings that apply foreign law, including any rights of avoidance.
Yes. Well, the point he's making is that since the exceptions don't include foreign law, including the remedies, then there's no reason to think that those are excluded, because they were not excluded under the old Section 304, which Chapter 15 replaced. Then there's question of the policy of the US law. There's another helpful bit, actually. If we go to 4553, as I mentioned, of relief there, the left-hand side column, if we start about 6 or 7 lines down, the court accepted that the use of avoidance powers created by foreign law would not offend Section 304, and the court allowed its avoidance action based on foreign law to proceed. In some under Section 304, avoidance actions under foreign law were permitted when foreign law applied and would provide for such relief. So there is specific mention of relief. in relation to the Metzeler case. And the conclusion here on the right-hand side, top of the right-hand side column, as Chapter 15 was intended to facilitate cooperation between US courts and foreign bankruptcy proceedings, we read Section 1521A7 in that light and hold that the court has authority to permit relief under foreign avoidance law under that section. So that in our respectful submission, was clear authority which the witness referred to at first instance. The next case, pretending to be a US lawyer, is Atlas Shipping, and that's at tab 119 just before. This involves a Danish insolvency.
You have an electronic page number.
I'm sorry, it starts at 4529.
4529. Oh, thank you.
Case of Atlas Shipping.
Yeah.
Here there were some maritime attachments. The question was whether they would be lifted. They were void under Danish law, the law of the insolvency proceeding. It's a question of whether the US court would give effect to Danish law. Page 4531, last paragraph, 2005, Congress adopted Chapter 15 Bankruptcy Code based on the model law and so on. Replace Section 304. That we've seen before. Over the top of page 4532, Section 304 provided a bankruptcy court with broad discretion in fashioning an appropriate remedy in a particular case. As having cited a couple of cases on that, Section 304C outlines several factors, including comity. The court must consider before granting a foreign representative any type of relief. Now, if we go to 4533, second complete paragraph, there is little doubt that under Section 304 and the Second Circuit's decision in Cunard and its progeny, the Rule B attachments would be dissolved as a result of the court exercising its discretion and granting comity to the Danish proceedings. Section 304 specifically permitted a court to order turnover of the foreign debtor's property, providing that such turnover was consistent with principles of comity. Then 4534, first complete paragraph about halfway down, there's a reference to the Danish Bankruptcy Act. Clearly provides that no attachments may levy against the bankrupt's assets after bankruptcy is announced. Both Cunard and Milovanovich stand for the proposition that attachments that would be void under foreign law should not be accorded special status just because the foreign representative initiated an ancillary proceeding here. Both cases also stand for the proposition that in such circumstances, the attachments would be dissolved and the funds returned to the foreign forum without prejudice to any of the creditors raising arguments in the foreign proceedings. Therefore, unless adoption of Chapter 15 altered the principles of comity recognized in Cunard and Milovanovich, the court would grant comity to the Danish proceedings and dissolve the 7 attachments filed after the Danish bankruptcy was announced. With respect to the 2 pre-Danish bankruptcy attachments, while Danish law is less clear, the unrebutted evidence also supports dissolving these attachments. Then if we go to 4535, could I ask the court to read Section C, Chapter 15, Relief, over the page and just before item 2. And then if we can move over, please, to page 4537, the last complete paragraph. The interplay between the relief available under 1507 and 1521 is far from clear. Nevertheless, legislative history confirms that Congress expected courts to interpret the provisions consistently with prior law under Section 304. And then another 4 lines down mentions additional assistance, different from the language 1521, allowing the court to fashion any appropriate relief to fit the circumstances of the case. And then at 4538, just towards the end of the footnote, at the top, last 4 lines, legislative history makes clear that Section 1507 is intended to permit the further development of international cooperation begun under Section 304. It is not the basis for denying or limiting relief otherwise available under this chapter. And that's, they can look at the statutory, the travaux préparatoires in the States, the discussions in Congress. Then we go down to point 4 at the bottom of 4538. Inquiry does not necessarily end there. The objecting creditors argue court's discretion. Comity to the Danish proceedings is limited by language of 1521. Court finds the argument unpersuasive, and that gives a reason for that, specifically referring to avoidance actions. Then next paragraph, 3 lines down, 1523A, grants the foreign representative powers of a trustee to bring avoidance actions only in full bankruptcy cases that we've seen. It's a reference to Condor. And then towards the bottom, there's a paragraph marked star 744. This is page 4539. Can I ask the court to read that? That refers to Metzeler.
This is referring to the lower court's decision in Condor, isn't it?
Yes.
Because the Federal Court of Appeals decisions after this one.
That's right. And it sort of, I suppose, vaguely disapproves of
Yes.
the first instance decision in Condor, which helps the appellate court in Condor. So that was the other case cited at that stage. This evidence was given before Hellas II, which in many ways an even more clearly point, and which I can take the court to. The same bundle at 118.
Thanks for interrupting. Is it Mr. Moss's submission that these were cases that were either cited to Bernstein or that you could look at them on the basis that you could form a view as to what His Honour Judge Bernstein's conclusion was based on? Because it's not clear to me why we are now, it's not clear to me why we're now diving off into US law unless it is on the basis that His Honour Judge Bernstein could have come to a different conclusion other than relying on the ECCA. So I'm not clear what it is, because I get a constant telling off from Mr. Moss about trying to submit about American law, and I haven't the foggiest idea why we're diving into it now.
Well, where this comes into the submissions is that What we say is that this is a question of American law. American judge has decided it. It should have been left to him, and that's the end of the story. But if I have to go on further to an alternative case, then I say, and we can check the citations, because we do have the submissions made to Judge Bernstein. I'd be astonished if they're not cited to him, or if he wasn't aware of them. I mean, these are extremely well-known cases in the same part of the US bankruptcy court. The person arguing the case for the liquidators, or one of the people, was Mr. Moulton, who was giving evidence. If no friend wants to be that finicky, we can check that point.
No, my objection is Mr. Moss should not be inviting the Judicial Committee of the Privy Council to say there were other grounds on which the judge could have come to his conclusion, because that is inviting this court to reach a conclusion on American law. That's my objection to these submissions.
Well, I think I was asked whether there were other justifications, and there certainly are. What you've got is you've got a judge sitting there with a whole load of questions, thousands of pages of submissions and expert evidence submitted, including by me, at huge length, and he's trying to get to a judgment. And he finds the easiest way of getting between 2 points is a straight line, and that's what he does. That doesn't mean he hasn't got in the back of his mind the fact that every available precedent in US law favored the same outcome. Yeah. And I'm reminded, very important point by my learned friend, the ECCA cites these cases. And so when he says, look at the ECCA judgment, he's saying, look at the ECCA judgment, citing these American cases.
You started this branch of your submission by saying that Judge Bernstein had taken a shortcut, as I understand it. And you said there were American authorities cited, but he took a shortcut and referred to the ECCA. Are you saying that he will have lifted these cases from the ECCA?
Well, I would say realistically, he knew these cases anyway. But I would add to that, and it's a fair point to add, is that when he refers in his judgment very briefly to the ECCA judgment, he is also referring to the grounds of the ECCA judgment, which is based on these American cases.
The perhaps slightly wider point I think I've understood you as making is that Judge Bernstein wasn't simply deciding a question of BVI law, ultimately he's applying US law, and these authorities are demonstrating to us how US law accommodates BVI law, but isn't determined by the BVI answer.
That's absolutely right, if I may say so. And we have to bear in mind here that if Lord Friend Lord Faulkner complains, it's entirely his side's fault. Both at first instance level and before the ECCA, we said you don't need to decide points of American law. Leave that to the American judge. Now, insofar as the ECCA, for example, went ahead and decided a point which really belongs to American law, and Lord Faulkner doesn't like the result of what they decided, I'm afraid that is very much his side's doing. Mm-hmm. It was his side who asked the ECCA to make a ruling on this, not ours.
You've taken us through Condor and Atlas Shipping. Is Hellas 2 where this ends?
Well, trying to keep it within bounds, yes. I mean, there are one or two places where, for example, the other cases are mentioned with approval.
Yeah.
Well, certainly Hellas 2 was founded on in the ECCA judgment at paragraph 73.
Yeah.
Yeah.
Yes,
Yeah.
so just carry on.
Hellas 2 is an important case which came after Mr. Moulton's evidence and therefore couldn't be in it. If we go to that, at tab 118, despite my friend trying to rubbish this case in terms of its eventual outcome, that doesn't really help the question that we're dealing with, which is the US law position about applying foreign law avoidance powers. And that is what this particular decision is about. And here, practically all the arguments that learned friends ran before the ECCA were run originally here in Hellas 2, including this very point, although on a similar provision in an English statute, not BVI statute. So, just to get the background of what's going on, could I ask the court please to read 4483, starting with the left-hand column about halfway down. Essentially, this was about Section 423 and 213, fraudulent trading claims. 423, of course, is an undervalued provision. But unlike 238, it requires an additional purpose, putting assets beyond the reach of creditors. And we can see that actually at page 4484.
Where do you want us to start?
Left-hand corner. It's probably not absolutely necessary to read 4483. That gives the background. We could probably start on 4484. We've got the particular claims we're interested in right at the top left-hand corner. Fraudulent transfer, as he calls it here. And the right-hand side column, 8 lines up, defendants also argue that amending the complaint is futile because each of the claims in the first amended complaint fails to state a plausible claim for relief. 1, a claim under Section 423 of the Insolvency Act cannot be adjudicated by a court outside the UK. So it's effectively the same point as being run here. And then 4485, left-hand side, halfway down. As explained below, court concludes that the first amended complaint was not filed in bad faith, not unduly delayed, not unduly prejudicial. Section 423 claim can be adjudicated by this court. Now, if we then leap ahead to 4494, under the heading of futility on the right, I ask the court please to read that long paragraph. Then from the bottom of that paragraph, please go to 4495, bottom of the left-hand side paragraph, bottom of the left-hand side column. As discussed below, the court concludes 1, it has subject matter jurisdiction over Section 423 claim under statutes enacted by Congress. 2, adjudication of Section 423 claim by this court is consistent with the UK's cross-border insolvency regime. 3, this court can grant the plaintiff relief under Section 423 of the Insolvency Act. So we say bang on point. No one has suggested that this has been disapproved, overturned, or in any way criticised in a subsequent case. There's then an analysis, 4495, right-hand side column, 423 in the reference to court. The slight difference there was that because Section 423 is not part of the corporate insolvency section of the Insolvency Act, 1986, the word court is not defined by the general definition for corporate insolvency, which you find in Section 251. So there is a special definition in 423 of court, which accommodates that, and also accommodates the fact that unlike Section 238, 423 deals both with personal insolvency and with corporate insolvency and with non-insolvency, where there's no insolvency proceeding. So the reference to court is broadened out to include, obviously, the High Court, which has full jurisdiction of everything. In the case of individuals, there are certain local courts, county courts, which have jurisdiction. In the case of companies, there are certain local courts which have jurisdiction. But all that's telling you is which court you're meant to go to. There is a very detailed treatment of this in our Annex 1, which I hope the court has had a chance of having a look at, or if not, perhaps overnight. Go to 4498.
Footnote 23 is quite interesting. It just it's a reminder of how one can't take anything for granted.
I'm sorry, I'm not.
Well, it reminds one can't take anything for granted when dealing with a foreign legal system. That in the US, apparently, determination of BVI law is an issue of law for the American court.
Yes, that's right. And under the federal system, and I believe it may be some of the states as well, like Delaware, the determination of foreign law is treated as a matter of law,
Yes.
which means that the judge is not restricted to witnesses. He can go and do his own reading,
Yes.
research,
Yes.
and come to his own conclusion.
Yes, and follows that his findings, his conclusions as to BVI law are subject to appeal to an American court as a question of law.
Exactly.
Yeah.
I was going to go to 4498, right-hand side. Got number 9 in square brackets. Court's conclusion that it has subject matter jurisdiction over Section 423 claim is bolstered by the following additional observations. First, Section 423(4) of the Insolvency Act appears to be a procedural venue provision clarifying where a Section 423 claim may be brought in the UK, while the court is bound to apply the substantive law in the UK to adjudicate Section 423 claim. Is not bound to follow UK procedural law. And then on the right-hand side, 4499, left-hand column, first complete paragraph, second, neither Isaacs nor Moss has identified any English decision indicating that Section 423(4) is an exclusive jurisdiction provision. However, even if Section 423(4) were an exclusive jurisdiction provision, this court is not bound to enforce it. And then about 10 lines lower down, there's a reference to the restatement. A state may entertain an action even though the state of the applicable law has provided that the action of a particular claim shall not be brought outside its territory. Consequently, a Section 423 claim is not futile on the basis that the court lacks subject matter jurisdiction over such claim. And then if we go to 4501, first complete paragraph under the heading, Court can grant relief under Section 423. In the Section 423 defendant's letter, defendants against whom Section 423 claim is asserted advance a new theory why Section 423 claim is futile. According to these defendants, the Section 423 claim would not survive a motion to dismiss for failure to state a claim upon which relief can be granted because, quote, Section 423 empowers only certain courts to grant the remedies set forth in the statute. And this court is not among the courts empowered under Section 423 to grant the remedies that plaintiffs seek. And then there's a discussion of seismic reservoir, which is one of these Canadian cases about internal management. We submit a totally different subject, and it is distinguished on that ground. And we can see, if I can ask the court in the right-hand side column, towards the bottom, to read the paragraph starting, this adversary proceeding is distinguishable. All cases seem to be about the Alberta Court of Queen's Bench for some reason. That paragraph finishes on 4502. Just stopping there for a moment, the court will recall that my own friend took you to the Xi Corporation case, which is a similar sort of idea, again, Alberta. What is slightly amusing about the Xi Corporation case is that that's decided not by an American court, but by the Alberta court itself. So it's the Alberta court itself telling the Florida court to keep its hands off its internal management corporate law. And then if we go to 4503.
Just before we leave 4502.
Yes.
Last full paragraph in the right column.
Yes.
Could there be some suggestion in that first sentence that the conclusion was to some extent dependent upon the location of the assets within the US?
In our respectful submission, no. That's an argument that's been around. But it's sort of expressing a doubt as to whether all the types of relief enumerated in 4251, that's the sort of shopping list of potential reliefs, whether every single one could be granted. But it's unspecific as to which ones might not be capable of being granted and why. It was very much a kind of en passant dictum, I suppose. The main point here is that this does hold undoubtedly that the US court regards itself, pursuant to a US statute, Chapter 15, as being able to apply foreign law, the foreign proceeding, in avoidance cases. And that's stated on 4503, left-hand side, right at the end, about halfway down the page. Based on the foregoing, the court concludes that Section 423 claim is not futile. The court can grant relief under Section 423 of the Insolvency Act. So, just going back...
Interrupting there, that bit is in fact the His Honour Judge Glenn expressing a view on the English cross-border insolvency regulations, not expressing a view of American law.
Well, you'll have an opportunity to reply tomorrow.
It was frustrating not to say that.
Just carry on, Mr. Moss, although I think you might be looking for an appropriate point at which to adjourn for the day.
I mean, in the 2 minutes I have, perhaps I can emphasize. Judge Glenn is the judge of the US Bankruptcy Court. He was applying a test of US law as to whether, under US law, Chapter 7, statute, US statute, he had the power to apply an English statute, avoidance statute. And that still keeps me within the 2 minutes.
But is there any public policy of BVI which means that the BVI courts should discourage the New York courts from doing that? The bankruptcy courts are not the New York court.
No, quite the contrary, my lady. As we submit in our case, it's exactly the other way around, as pointed out by the ECCA itself. The policy for a small island, which incorporates companies which do business entirely abroad, largely in the United States, their policy is even stronger than the policy of the UK, for example, to ensure that they will be assisted by other countries' courts in cross-border insolvency cases.
And we have the benefit of the views of the local court on that matter.
Exactly, and in fact, Chief Judge Pereira, very experienced, one sees her in a number of leading insolvency cases. She's very experienced in this field, certainly knew what she was doing.
Well, if that's an appropriate moment, Mr. Moss,
Indeed, Lord.
then we'll adjourn.